Good afternoon, and thank you for joining us for today's episode of Legal Learning. Today we'll be talking about how to navigate small claims court. Our presenters are senior law unit attorneys Joanne and Geraldine. With that, I'll hand it over to Geraldine to get us started.
Okay. Good afternoon and welcome to Coast Legal Aid of South Florida's Legal Learning. I'm Geraldine DiBianchi, the Mobile Justice Squad attorney in the Senior Law Unit, and I am joined by Joanne Gallipol, our lead consumer attorney in the Senior Law Unit. Today we will be discussing understanding small claims court. Joanne, please tell us.
Hi, good afternoon to everybody. My name's Joanne Gallipol. I'm the senior litigation attorney, consumer law attorney here at Coast to Coast Legal Aid. And I just wanted to give some tips and some information regarding small claims court because we get a lot of calls during the week from people that are receiving these notices. And I thought Geraldine and I believed it would be helpful just to go over some of the information with you all so you have it in advance and you don't have to stress out too much about what's going to happen. We'll talk about the rules first. I mean, small claims involves any amount in controversy that's $8,000 or less. These cases are different than county cases and circuit civil cases, which have a higher amount of controversy. So oftentimes we see credit card cases that are small claims or, personal loans or anything that's not secured to a property usually. So unsecured debts could be a car repos. It could be a lot of different things, but usually it's credit cards. The pretrial conference is an opportunity to go in front of the judge and try to get this resolved before additional litigation conducts. Because of the small amounts that are being litigated, I think it's worth it. The judge and the courthouse has determined that it's just worth it to try to resolve these claims quickly and put everybody on proper footing so you don't have to continue to litigate. You're going to end up probably at a mediation. We'll talk about that as we go through the slides about what the mediation is and the importance of it. And we're going to talk about how to put yourself in the best position to be successful at a pretrial conference and to get this matter resolved. The pretrial conference is supposed to be scheduled at, within 50 days of being served with the summons. I'm going to show you a copy of what that summons will look like. The purpose, as I said, is to, go before the judge, find out what's going on in your case, and hopefully come to an agreement that's going to get this resolved with the mediator's help. If you need to reschedule a pretrial conference, make sure you contact the courthouse as soon as possible. If you know that you're going to be on vacation or you have something planned that, is going to be very difficult to move, call the courthouse as soon as you get the summons, talk to the judicial assistant, tell her you're not available. I think because these are relatively, I'm going to say quote unquote simple cases, you have a decent chance that the judge will just move this hearing to make it so that you can attend. They don't want to hold the hearing without you. That defeats the purpose. These are copies of the summons that you might receive. And I put two different summons up here just to show you the difference. This is a small claims summons here on the left. If the process server comes to your door and hands you this summons on the left that says pre-trial conference, it may be remote, it may be in person, you have to check. You're in small claims court. It's going to say how to appear. If it's at the courthouse, it'll have the address and the room number. If it's via Zoom, it'll give you the Zoom link, kind of like this one does down here, so that you can attend, and it's going to have the date and time of your hearing. If you get a summons that looks like this one, you're not in small claims. You're going to be in county court or in circuit civil, and these require you to actually file an answer as opposed to appearing for a pretrial conference. So small claims court is the only court where you're going to get a summons that requires your presence at a hearing with a mediator. Otherwise, if it's $8,001 or more, you're going to have to file an answer, and you're going to know based on what the process server hands you.
Tell us how to navigate the pretrial conference, please, Joan.
Sure. You know, when you get there, there's going to be a lot of people, by the way. It's not just a hearing for you and the other side. There's going to be a courtroom full of people, probably. And if you're on Zoom, there's going to be a lot of people on the Zoom call. You are going to be called by the judge or the clerk, potentially, and probably immediately sent off with a mediator. If it's in person, you'll be in a mediation room. If it's on Zoom, there will be breakout rooms. And you'll have this mediator who's a neutral third party there to help get this case resolved. If you settle the case, the mediator is going to write up the settlement. Everyone's going to sign it, you and the other side. They're going to give that signed agreement to the judge. And more likely than not, the judge is going to dismiss the lawsuit and everyone's going to be bound by that new agreement. If anyone breaches the agreement, you go back before the court and the judge will pick up the case from there. If you're unable to come to an agreement, there's really two things that can happen. You can either tell the judge you just don't have the means to make payments on this debt that the other side is alleging, in which case a final judgment will be entered in favor of the other party that says they're entitled to money. And it'll be up to the other party whether or not they want to try to collect that money later on, usually in the form of a garnishment. If you go before the judge, however, and you say it's not my debt, which is something different, the judge is going to set this for a trial down the road, a non-jury trial. And maybe you're going to tell the judge the amount is incorrect that the other side is seeking, or you've made your payments, or this was identity theft, or whatever your defense is. If you're not going to admit the debt and you can't settle the debt, you're going to be scheduled for an additional hearing. So when you go to a pretrial, you want to be prepared to answer the questions the judge asks you and, you know, be professional, be courteous. The point is to get this resolved without further litigation if possible. We already discussed the purpose of the mediation. It's to try to resolve these cases without having to hold a trial. We talked about the role of the mediator. He's only there, he or she is only there to try to bring the parties together. It's a confidential environment. The mediator doesn't have a stake in anything. They hear both sides of the case and they try to help you come to a resolution.
How do we prepare our pro se litigants for a court appearance?
Yeah, you're going to want to bring, if you're pro se, you don't have an attorney going with you, you're representing yourself. That's what it means to be pro se. So, you know, you're going to be with a mediator. Bring stuff with you that's going to help, you know, substantiate your settlement offer if you have one. So if you have a contract, if you have payment, proof of payments, pictures or paperwork that support your case, you could bring that. You do not have to bring all your witnesses, or if you have a ton of evidence that you're going to want the judge to see, you don't need that for pretrial conference. That'll be later at trial if you end up at a trial. So just plan on only being able to really discuss the case in depth with the mediator and the other party, not with the judge. Make sure you bring a calendar so you can write down special deadlines that you need to adhere to, trial dates, or anything else of importance that the judge says. Be on time. If you are not on time, or if you just don't attend, the court, meaning the judge, will issue a default. And basically that means that you are in agreement with all of the allegations in the plaintiff's complaint. So it's as if you have no defenses, and it prevents you from coming into the case later and addressing the judge unless you file additional motions and get additional hearing dates. You don't want to be in that position. So if you're on Zoom, don't plan on getting there on time, plan on getting there early. Make sure you don't have any technical issues, make sure your internet's working well. If you're going to be in person, plan to have to park at the courthouse, get through security, find your way to the courtroom. Do whatever you can to avoid being late. It's a real pain to try to vacate a default, So you need to be on time.
Yep.
If you don't understand, oh, sorry, Geraldine, go ahead.
No, I was echoing the sentiment.
Yes. And if you don't understand something, whether it's something the judge says or the mediator or the other party, you need to ask for clarification. There's nothing wrong with that. You're not an attorney. So everyone will understand that maybe there's something that you need to be explained further. Just make sure you ask. You don't want to walk away from the hearing with questions. We already talked about staying calm and courteous. First of all, this is not the trial. This is just to bring the parties together to try to settle the case. It does not help your case if you're not using decorum in the courthouse. The judge, the mediator, they will take note of that and not really go out of their way to help you any further. So I would say it makes a real difference when you're calm, you're courteous, you're listening, paying attention. There'll be plenty of time later at trial to make your arguments if you end up at a trial. We talked about staying organized. You don't want to miss any important deadlines.
And again, we are Coast to Coast Legal Aid of South Florida. These are the areas of law that we practice in. Please follow us on Facebook, Instagram, X, TikTok, our YouTube channel. Look for us at noon on Thursdays for Legal Learning, Fridays for Fridays with Friends. We hope that you took away a lot of helpful tips from us today in preparing for small claims court. Thank you so much.